make it available after. Okay, this topic, wills and trusts, may seem as though, where does this apply in my situation? So we've decided to conduct this through Q&A and interview someone today and offer up the ability for you as well to ask some questions. So the format will be a little bit different as what we've conducted our plan series webinars in the past, but we know that this will be beneficial as we go through the program today. So for those who aren't familiar, a little bit about myself, Justin Baumgren, a certified financial planner, chartered life underwriter, and I've been an advisor for about 20 years, and I am president of Baumgren Retire Plan, a fee-only financial planning firm that specializes in retirement planning and the various needs there. And I'm also a co-founder of iDecisionPlan.net, a personal finance website that creates unique visualizations for financial decisions. Today, we're going to be interviewing Rodney Piercy. His contact information is there. He is the founder of Piercy and Associates with a career that spans nearly 50 years. So an expert in the field, actually rated as one of Chicago's top rated lawyers. And most of his career has been helping affluent and high net worth clients in the areas of estate planning, asset protection, and tax elimination planning. So again, this contact information, I'll display it at the end of the program in case you're feverishly trying to write this down. We'll bring this back up a little bit later. But just a way of some housekeeping, how we'll be conducting our webinar today. As in the past, I encourage you to use the chat feature. As this is a Q&A, many of the questions that we've developed will be specific. We've pre-planned, but we want to entertain questions that you might have as well. So if you look in your Zoom feature there, you'll see the chat, and we'll be keeping an eye on that as well. So feel free to use that liberally, the chats. Wills and trusts, why is this important? Well, you might, of course, if you are Elon Musk, there's an obvious need for estate planning, and you wonder, well, do I really need it? Well, we found, at least in my career, that even if we're not Elon Musk, we sometimes misunderstand where the true need is. And we may find areas in here as we go throughout our program today where you might uncover specific need for some estate planning needs. But in particular, again, wanted to just introduce Rodney Piercy today. I'm excited to speak with you. Thank you for joining with us today. In fact, I've worked with dozens of estate planners over the years, collaborating with clients on different aspects. And one in particular why I wanted to invite you today is as we were collaborating with another client on some needs, I appreciated your focus on ethics. So, and I'm sure you can agree that in both of our industries, that's sorely needed, strong ethical values. So I appreciate you joining us today as we go through our webinar. So let's dive right in if you're ready, Rodney.
Ready to go.
Okay, well, let's start in my mind at the top. Let's talk a little bit about where many times clients get introduced, they hear this hot button issue about probate. Let's talk about probate. What is it? Where does it come from? And why do we not like that word?
Sure. So probate comes from the Latin word probare, which means prove. So more than 100 years ago, just about all of our states, laws were passed which require you to prove you don't owe money to anyone before you can give money to your loved ones or your charities of your choice. And so the probate is a court case And if you have real estate or pretty much anywhere from each state's number is a little different, from 25,000 all the way up to 100,000. If you have investments in that range or a house, you have to go to probate. And now it's not you, it's your estate because you've died. But yeah, your estate has to go to probate. And this is a long, expensive, risky process, taking no less than 6 months. Average is probably 1.5 years in court. No money can come to any loved ones, other than there is a widow's award of 20 grand that can happen. Other than that, everything's tied up until you get out and prove you don't owe anybody, and then the money can be distributed either pursuant to the Probate Act of a state. So another way to say it is, your state has written a will for you if you haven't written one for yourself. In Illinois, you can't disinherit your wife. If you do disinherit your wife in a will, she still can get half if there are no kids, or third if there are kids. But so anyway, probate is a court case. George Hallis, who used to own the Bears, his probate lasted 18 years because there was squabbling going on over the Bears. But so probate is expensive. It can cost anywhere from $2,000 or $3,000 up to 25% of everything that's in it. Risky because creditors come first before your loved ones or your charities, and a lot of work for lawyers. Lawyers wrote the law, so guess who gets paid first in probate? Yes, you're right. Lawyers, then the creditors, then the family. So that's where you are, whether you have a will or don't have a will. So once people understand how bad probate is for their loved ones, they generally want to avoid it.
Yeah, so true. Yeah, thank you for that nice background. And you highlighted some key aspects: the cost, of course, the time frame. With that being that it's public, it can be a bit invasive at times. And what about some ways that we can avoid this?
Well, there are a number of ways, but only one of them works well. You can name beneficiaries on investment accounts called transfer on death. You can name beneficiaries on an IRA. Can't really name beneficiaries on a home. So that's out. But as far as IRAs, things, you can name beneficiaries. The problem with naming beneficiaries is there's no possibility of delaying it for young people, so they get it all at 18. If they die, then it could go to probate because you can only name them. You could say, I named my son, if he dies, his kids, but then those kids might get it. So you can use beneficiary forms, not for a house, but it doesn't work very well. And there's no way to protect an IRA for children. When I say IRA, I mean 401k, anything tax deferred. I'm just going to call it an IRA, but you can't protect those from lawsuits against children after they get it if you just name them. You could through a properly drafted trust. So the best way of all to avoid probate is a living trust, a revocable living trust. Now you're going to say, that sounds like the Kennedys and Rockefellers. Yes, they have them. But if you own a home, even if you have little equity in it, you basically are a candidate for a revocable living trust. What is it? Basically, it's a bucket that you create. Ours is about 35 pages long. It has all the what ifs covered, all the protections for children against divorce and lawsuits and delayed for young, all this stuff. So you create it, then you got to, quote, fund it. You've got to put in your home with a deed. You've got to name it as beneficiary of these accounts or owner of these accounts. And then you can live your life knowing that when you pass away, the money would be immediately available to your loved ones with no delay. no cost, and no risk. So once people understand probate and trusts, 99.9% of the people want to get a living trust.
Good. Yeah, thank you for explaining that. Many of us are familiar with beneficiary type forms offered through, as you mentioned, retirement accounts, IRAs, 401ks, even life insurance, TODs. They can name beneficiaries, but as we kind of highlighted, it does cover a lot, but not all. And it's certainly limited with different distribution techniques, as well as creditor availability. So it has its limitations. So talking about, you've mentioned wills and trusts. The best way to avoid then probate is through trust. So let's talk about what types of protections then. What are we trying to protect ourselves with besides creditors with the trust?
Well, young people getting money. If you leave an inheritance to someone who's 10 years old, the day they turn 18 at midnight that day, they suddenly become incredibly competent and wise under the law, and they get it all at once. You can delay that, provide for their needs, get them through college, but then give them maybe a couple of installments when they're in their late 20s, 30s. Soft landing for the money is how I describe it. So you can do that with a trust. You could do that in a will too, but probate first. Then when you're done with probate, the trust in the will is set up going forward. But you can avoid the probate with having it all in the trust. Now, just a quick note, if you have a trust, you need a very short little will because you could forget to put something in the trust. So the will says, we have a 2-page will. It says, if I forgot to put something in my trust, it goes in after I die. So we do that as kind of an insurance policy. But yeah, a trust can protect against creditors, can protect against kids' creditors. It can protect against kids divorcing spouses for both IRA money and for qualified, non-qualified money. So there's all kinds of protections that are available in trusts that you really can't get on a beneficiary form.
Yeah, very good. So what you described has a lot of the same features that a will has. So what's the difference between a will and a trust? Besides one helps us to circumvent probate, the other doesn't. Oftentimes we use them interchangeably. What's the difference?
Well, a will is a document that literally has no legal effect while you're alive. It springs into existence when you die, and then it controls everything if it follows all the formalities. If it doesn't follow the formalities properly, then it is actually a bunch of lawsuits happening. But a living trust, you live out of it while you're alive. You can change it anytime you want. It has no tax return or tax number. It's just your own private little bucket that you live out of. And so its differences will springs into effect when you die, and thereafter can't be changed. Trust just springs into effect when you sign it, can be changed as long as you're alive or your spouse alive, but when you both die, then it becomes unchangeable and governs. And you can say the same things in both, i.e. My disabled son doesn't get the money, it goes into a special needs trust. You can do that in a will or a trust, difference being probate.
Yeah, very good. Okay, thank you for highlighting that. Well, let's talk a little bit about a couple of things, portability and cost with related things. So first off, say hypothetically, we had some work done, 20 years ago. Trust was done 20 years ago. Do I have to monitor this thing? Is it still good?
Well, it's probably still legally valid. A couple of things happen over 20 years. Sometimes people buy a house, sell a house, buy a new one. They forget to put it in the trust, at which point then they got a probate anyway, even though they had a trust. But also the laws have changed a lot, especially laws relating to retirement funds. And so it may be legally valid, but it may not work. We've had cases where the Schwabs and the Pershings and Vanguards didn't want to let an IRA run through a trust because the trust hadn't been amended in the last 5 or 6 years, and then it was going to probate. So it's good to get it done. It should last you the rest of your life, but it is also good to keep, check on it every 5 or 10 years. Have somebody who's very skillful look at it and say, yeah, this is great, but paragraph 4A needs a little tweak here so that we don't end up in a problem with the IRS.
Yeah, that makes sense. Well, kind of a similar vein. You mentioned, in the case where you've purchased a new home, forgot to fund it. Speaking of that, what about moving? What if you moved out of state? Are these?
Yeah, many people. I work in Illinois, as you can see from my contact information. Many people are leaving Illinois right now because, matter of fact, it's one of the top states in the country for people leaving. They're going to places which are more friendly from a climate as well as from a tax climate. And so our trusts are good in all 50 states, and our wills are. There are a few documents that we do as part of our estate plan, healthcare powers of attorney, enabling you to not get stuck on life support, property powers of attorney, allowing for your spouse to draw money out of your IRA if you can't function. These should probably be redone when you move, but it's not a big ticket item. Those are fairly inexpensive compared to the whole plan. And so that brings us to cost. There's a very wide range in fees, and there's a very wide range in skill levels in this area of the law. You could go on LegalZoom and probably pay $300 or $400 and get a trust. Unfortunately, it will only provide 3 or 4 of the 25 protections currently available. None of the ones that are really important to you, other than maybe avoiding probate. But then you don't know how to do the deed. You don't know how to make it all work. So that's the low end. The high end is probably $20,000 for a big law firm to do these 10 or 12 documents for you. And in the suburbs, where firms who do nothing but this, pretty much around the country, it's probably, for a single person, it's probably a $3,000 to $5,000 range for everything, again, which should last the rest of your life. And for a married couple, probably 4 to 6. Again, smaller firms, not the big firms. Big firm would be in the $20,000, $25,000, $30,000 range. And then if you're a married couple with estate tax issues, it could be, $6,000 to $9,000. But compared to the cost of a probate and the risks and delays, it's a cost that people generally feel is worthwhile.
Yeah. Thank you for kind of highlighting that wide moat there. So you got the economies that are a few $100s, but that's really risky business. And then you've got the super complicated, depending on the needs. But boutique firms like yourself tend to be a nice blend of both. So appreciate the candor with that. Speaking of, with regards to estate planning, 2 kind of topics that often come up with regards to wills and trust. The first one, as we've already talked about, has to do with the underlying theme of probate. Now, the other one, we're just going to put it into another camp, using some air quotes, and that's inheritance tax. That's where the other hot button, where it may prompt clients to think about some estate planning, because we want to avoid taxes if it possible. So let's talk a little bit about that other aspect of estate planning, this estate tax.
Sure.
So
Sure.
That's changed quite a bit, and I know you don't have a crystal ball, but can you talk a little bit about the exemptions currently historic and what you see in the future?
Sure. Well, Illinois has an estate tax with a $4 million tax-free amount. for a couple, or if or an individual. But if the couple does some planning with two trusts, they can double that to 8 million. Again, a lot of your clients are moving to Arizona, Florida, Tennessee. Those states do not have an estate tax. So then we're going to jump into the federal estate tax.
Mhm.
The current federal estate tax law allows 12.06 million each for a spouse, a husband and wife each, without any planning, just wills. However, yeah, even but the problem with that number is that in 2026, the law which created it expires. And then it's going back to around 6.5 or 7 million each. But the problem that we see happening is people with 3-4 million who are in their 60s it's likely to double 2 or 3 times, even at a modest growth rate, before they reach their joint life expectancy. So it is a real issue. The federal estate tax is 40%. Illinois is 16%. So it can be more than half if you're in a state. There were some laws proposed last fall that put the number at 45% and dropped the tax-free amount from 12 down to 3.5. It's a moving target. I don't have a crystal ball, but we do know that if government keeps spending money the way they are, all taxes are going to have to go up, including the death tax.
Okay, already, if I'm putting that together, you said 40 plus possibly another state level 16. So we're already over half, with the possibility that can increase. Now, just a little sidebar, what if we feel like we might be in that category, what might we need to consider?
Well, we've got about 70 tools. The good news is the estate tax is voluntary as opposed to income tax. And the only people who pay it are those who haven't done proper planning. And most people don't do proper planning because they are busy, and don't plan to die next year. But yeah, it's a process where we first talk about, we look at someone's financial picture. You tell us what growth rates to predict. Then we tell them what their estate tax will be when they both pass away. And then we decide, okay, what's appropriate for your unique situation as far as this tool versus that tool. But we have lots. We have some that you can actually get more for your family by giving things to charity, as surprising as that may sound. And we have others that don't have anything to do with charity. So it's an area, unfortunately, it's a little more complex than the discussions we've been having. It does deserve its own separate discussion.
Yeah, good. And, the key takeaway here is, if we feel like that might be, of consideration, it's wise to discuss that sooner rather than later. So hopefully those that may be thinking about that, it may prompt some further discussions in the future. So, but we've left a few minutes here, Rodney, just to entertain any questions that the audience who's live here might have. So we want to encourage those. If you have any questions, feel free to use our chat feature on Zoom. But while we're thinking about those questions, just want to again thank you. I know you're very busy and you just came back from vacation recently as well. I know that's especially difficult coming back, getting unburied with that. So thank you so much for taking the time today to speak to these particular topics.
Well, you're very welcome. I do love to educate people about these matters because people make better decisions when they have some information. And by the way, many times people don't want to ask questions publicly. I will be happy to speak with anyone on this. You've got my contact information. I will talk to you at no charge to answer any particular questions you have. So we do have a question.
Yeah, good. I don't know if you're able to see that there, Rodney, but it says, do firms give you an idea of the cost before you go in? Is there some transparency with fees? And just to add to maybe that question, what would the cost be for just a review of for those who maybe already started some planning, but maybe would like to have a second pair of eyes look at it. So if we could maybe add that to that current question there.
Sure. So the answer is that it's very important that you have a clear understanding about the cost of a first meeting, and that at the end of the first meeting, whether it's an hourly charge for the work being done or an agreed fee, we recommend you not work with lawyers by the hour, because the longer it takes them, the more money they make. And that's not a good stream to swim upstream for them from an ethics standpoint. So we will review anyone's plan for a financial advisory work with at no charge. I don't care if it's 5 binders. I will do a quick review and say, you know, you do have an estate tax, you do not have one, assuming we have your financial information. And you need, this doesn't work anymore under your state law because of this. So we feel that we can give back to the community by doing free reviews of plans, and it's makes it hard for people to procrastinate.
Good way to put it. Yeah, excellent. So I think that answers that question pretty well, and I don't see any others in there. So I'm going to go ahead and share your contact information on the screen, since we've got about a minute left. But again, thank you, Rodney, so much for your time today, and hopefully we'll invite you back for an upcoming one in the future.
Great. It was great to be able to share this with you. Thanks a lot.
Thank you.